Everybody, nice to see you. Still loading in there. Fran McGovern here. Happy Friday. Happy New Year. I don't know if it's too late to say Happy New Year. What is today, the 9th? Like, it's probably getting a little stale by now. But feels like spring out there the past couple days. Um, so that's nice. Nice break, 2, 3 days. Um, Great to see everyone. Thanks for coming out. I think everyone is in now. Yep. Yep. Okay, great. Um, So what's today about? Today is litigation, the slow and expensive wheels of justice, right? So everyone knows this. Lawyers tell you this all the time, but it ain't like TV, right? It ain't like TV. You don't have a 45-minute TV show that, I don't like you. You did something wrong to me, and I'm going to sue you, get all the way through a jury trial, and have victory, dance it down the stairway to the courthouse, and get a big fat check. That's generally not how it works. It usually involves years and years of costly litigation. Well, let me take a step back. What is litigation? Litigation is a formal and a formal process of dispute resolution uh, worked out through the court system, right? So that's what litigation is. And that's what we're talking about today. So I got a little ahead of myself there. And I even skipped dog of the day and I skipped my crazy announcements, right? So let's do the first announcement. These webinars are provided for general informational purposes only. They do not constitute legal advice, and they can't form an attorney-client relationship, right? The information exchange does not constitute legal advice. To obtain legal advice, you must go out there and hire an attorney. As I always say, and this seems really biased, and it is, I prefer you hire me. Hire McGovern Legal Services. So I do appreciate that. Many of you, I'm preaching to the choir, and you're already clients, which I really appreciate. Thank you so much. I see Maddie out there. That's awesome. So you have to enter into a fee letter and get real legal advice. No information will be discussed that will be kept confidential, right? So this is all being talked about. So if you put something crazy in the chat, that's on you. Hopefully you won't. No pictures, please. Edward says no pictures. No, that's good. Thanks, Edward. The the dog of the day. The dog of the day today is two dogs of the day, and that's Bonnie Hendricks. Bonnie Hendricks is a property manager for Executive Property Management. They're based in North Brunswick, New Jersey. They're statewide. But Bonnie is an on-site manager over at Marlboro Greens, right off Route 9 there. So thanks, Bonnie. This is Henry and Lucy, Welsh Corgis, very fancy dogs. You see them in dog shows all the time. Beautiful dogs. Nice to see you, Henry and Lucy. We will see you on the calendar next year, I suppose, right?
Yes.
So thanks, Crystal. Really nice. Great. Thank you. What do we got? So back into litigation. So litigation is, again, not like TV. It's so far away from TV and beyond the time and money it takes, what people really underestimate is the amount of angst and heartache and time you personally have to spend with all this nonsense, right? So I'm sure many of you have been through long careers where you've been involved in litigation at one time or another. And people get so frustrated because they have to show up for a deposition, and the deposition gets adjourned, and one of the lawyers is rude, and you don't finish the deposition. You have to come back the next week, and you're going to go in for a motion hearing, and the motion hearing is adjourned, and you're there 2 weeks later. And how come the case isn't moving? And why are we wasting all this money on these stupid lawyers? All that craziness just drives people nuts, right? It drives people nuts. So there is a real personal cost in terms of angst, right? So there's dollars, right? There's time in terms of how long the case lasts, but there's a lot of angst in terms of your personal time, frustration, aggravation, etc. And so don't forget about that cost when you're thinking about either pursuing litigation or not settling a litigation. So again, it's a formal process and it's in the court system. So it's a public service, right? So that's one of the things. It's a public service that the government provides. A government provides a court system, a judicial system, a judiciary to resolve disputes. And there, as you know, there are all different levels of judiciary. There can be state, there can be municipal, there can be federal. And this is a hot topic right now, as you see on TV every night. Where does the dispute belong? Can I have a lawsuit in state court or should it be in federal court? And can I remove it to federal court or should it be sent back to the state court? does a state legislature make decisions that are binding, or does the federal government make decisions that are binding? All those fun things are really, really, really being kicked around the courts right now, and some of them are going to the highest court in the land, right? The U.S. Supreme Court, right? The U.S. Supreme Court. This is probably one of the high points of any constitutional law professor's careers, right? Because they could teach con law today in law school right from the newspaper, right? Because all of these issues are coming up on the front page of the newspaper. Who has jurisdiction? How should jurisdiction be handled? Who should make the decision? Is it binding? Does the executive branch have power? Does judiciary have power? Should the legislature be acting, right? So it's really, I know it's really a crazy time out there, unless, well, I guess not unless, especially if you're invested in the oil industry at the moment. That's a little wacky at the moment, because we got barges and tankers and so forth being intercepted and billions of gallons of oil affecting the market. But so it's a crazy time out there, and all these challenges are affecting the system. How does it affect us? Most of it not directly in terms of association world, thank God. But what does happen is the litigation mindset does bleed down into our communities. And that's for real. That's for real. And I'll sue you. If the board doesn't do what I want, I will sue you. If the board doesn't do things that I say, I will sue you, right? It's an approach to life. It's a philosophy of life that does bleed down into the chairs of the members in your community, which is a very, very bad thing. And I know I'm not following my agenda right now, but the one thing to think about, that is the main reason for something called the business judgment rule. The business judgment rule essentially says judges should not be running your communities. Judges should not be running your communities. The court system is not equipped to run your communities. The court system shouldn't be making day-to-day decisions for communities. You shouldn't be showing up in court every time you disagree with the board or the board disagrees with you. And the business judgment rule, in a very rough sense, says, listen, if the board was authorized to do something by law and or the governing documents, and the board members are not engaged in self-dealing or fraud, the court should defer to the board's business judgment, right? That makes a lot of sense, because otherwise, who lives in an association where there are no disagreements, right? Nobody does, right? So judges find themselves, if they didn't have the power to invoke the business judgment rule, having to weigh in on every one of these decisions. Well, I didn't like the landscaper you chose. The auditor was a bad lady. We don't like her either, right? All that nonsense. And people actually do go to court over this stuff. And what they forget, as I just see in my little dollar signs there, is what you're doing. It's like feeding a furnace. Bust out a shovel and shovel piles of money into that furnace, right? Because that's what you're doing. It's just money, money, money. The lawyers are winners in any case, right? So as every judge will tell you, as every mediator will tell you, as every arbitrator will tell you, you should all do everything reasonably possible to amicably settle your disputes, right? That's easier said than done. Easier said than done, because the first question is, Fran, what do you mean by reasonable? They're not reasonable and we hate them. And the other says, they're not reasonable and we hate them. We hate everybody, right? So as you know, some of these disputes just devolve into madness. But getting back to the agenda, which is the actual kind of working of litigation, how it works, why people get so annoyed with it. So this, I could have had a little graphic, but I don't. So this is the court rules. This is the court rules. This is a copy of the court rule book. The court rule book contains the procedures for how things work through the courts. These are not laws per se. These are more like the instructions for the court, the instructions for the game. So if you open up a board game and, in the box, there's all that little print on the box lid. These are what you do, what you have to do in 10 days, what you have to do in 30 days, when the papers have to come back, all that stuff. It's not about the actual statutes of you can't park there or you can't kill people. right? It's not laws in that sense. It's how the courts run. These court rules also contain many other important things. One, the rules of professional conduct, which guide attorney conduct in practicing law. Because I know people say this as a cliche, but lawyers are actual officers of the court. And the court can do whatever. The Supreme Court is the ultimate arbiter in an attorney's license with respect to any ethics issues. And the Supreme Court of New Jersey, I'm speaking about, can step in and discipline an attorney, take an attorney's license, suspend an attorney's license. And those rules of professional conduct are in here as well. In addition to that, there are rules of judicial conduct in the court rules that govern how judges must conduct themselves, which makes a lot of sense, right? Because lawyers shouldn't be doing bad things and judges shouldn't be doing bad things. Why? Why is this so important? Why is America so proud of its judicial system and the judiciary? Because, at least in theory, although this is in doubt sometimes today, America is a country of laws, not of men, not of women running things, right? We should be doing and conducting ourselves based on the rule of law, not on the rule of men, right? So whoever that fellow was that got arrested from South America, he was a despot, apparently. I don't know anything about him, really. He might have been a really nice guy. I doubt it. Who knows? But he was a guy who said, this is the way it is, and stuff happened. And if it didn't happen his way, apparently he got disappeared, right? So the odd thing about all this is there's a lot of conflict right now between the various political parties in the U.S., especially at the federal level, and between and among the states as well, where they're making similar claims. Wait a second, I thought we were a country of laws, and it seems sometimes like we're being operated like a country of men, right? So that's a really important distinction, and we should be guided by law, right? Guided by law rather than decisions made by either one man or one woman or groups of people, unless it's provided for in the legislature, the Constitution, and statutes. So that's the rule of law. Getting to ADR, ADR is a way to derail litigation, step out of litigation, try to settle it amicably prior to getting crazy in litigation. It's usually mediation or arbitration. Mediation is a little bit more informal. Mediation is generally aimed at having the parties agree to a solution on their own. There's not a solution imposed upon them. Arbitration, on the other hand, is kind of like litigation light. There's actually a whole series of books and procedures on how to handle arbitrations, and it's usually handled by a panel, and you wind up with an actual binding decision at the end of arbitration. So many times in today's world, an arbitration may be as burdensome and costly as a court case, an actual litigation that goes to court. What about, it's a topic for another day, because I'm going to do a seminar, and I've done it before, on arbitration, ADR, mediation, everything. So we won't get crazy on that. But surprise, you're back in ADR anyway. So people say, we are never going to settle this case. We are filing suit against you, and we don't care. We're moving forward with litigation. And you find yourself in front of the judge for a case management conference, and she or he says, guess what? I am referring this case to mediation or arbitration. Yeah, judge, but we don't want to go there. No, 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 no. Leave me alone. We're not going to settle this case. Screw everybody. The judge says, that's really nice. You're going to arbitration or mediation, right? So in New Jersey, the courts very much favor amicable settlements and ADR. So even though, especially in the association context, even though you don't want to go there, the judge is going to compel you to go there to give it a shot. He or she can't compel you to settle the case, but he or she can definitely send you there and make you participate in the process in good faith. And a lot of things do settle that way, which is good. Why is that important for judges? New Jersey courts are, in many respects, understaffed with judges. It's hard to find good judges. Judges have mandatory retirement ages of, I believe it's still 70, but they can come back on recall, but many of them do not. Why? Because many judges who are still in good shape and interested in working can do ADR, right, in private practice again, mediation, arbitration, and charge between $750 and $1,000 an hour. Not a bad gig, right? Not a bad gig, right? So, think about it. If any of you are retired judges out there and you want to do ADRs through McGovern Legal Services, we have an office for you. Come on down. So the retired judges often do an outstanding job with mediations, arbitration, but the costs are significant. Costs are significant. I do mediations for associations that are not my client. Knock on wood, often successfully, but I can't do them obviously for associations that are my client. So I do them out there, and my fees are not cheap, but they're also not anything near what retired judges charge. And many other attorneys in the association industry do mediations as well. For example, I've worked hand in hand with Caroline Record, if any of you know Caroline, for some time on doing mediations and arbitration type things. She does a nice job. So ADR topic for another day. Surprise, you're back in ADR. Okay, let's assume ADR does not resolve things. What is the complaint? What is the complaint? The complaint is, and you've seen them online, the complaint is, this is my problem. This is my problem. The association didn't do what it was supposed to do. It broke the law. I am somehow damaged, right? So the thing to think about in the most simple terms with a complaint, what you should be outlining is really four things. Duty, number one, duty. The person you're making the complaint against has a duty. He or she should have protected me. He or she should have been more careful. He or she has an obligation under the association's bylaws. That's duty. Breach of that duty. They failed to uphold the duty, right? So they were supposed to be careful, but they weren't careful. That's a breach. Damage. So they had a duty, they breached that duty, and then there was damage, right? Someone got hurt, someone got their fees too high because they misallocated the percentage of the fees they owed, things like that. There's damage, they paid too much money. And then the fourth thing to think about is there has to be causation, which is a link between duty, breach, causation, and damages, right? There has to be causation between breach and damage. So one of the classic examples are, I'm not supposed to do dangerous stuff. I have a duty to behave in a responsible way if I own a firearm, a handgun. And I just walk outside my office today and I fire the handgun up in the air, straight up in the air. So I have a duty to be careful, right, with the gun. The people outside go, oh my God, Fran McGovern just went outside and fired the gun up in the air. That's breach. He shouldn't have done that. He was not exercising reasonable care. He's in breach. Let's sue him. But the bullet just goes up in the air and comes down and lands in the grass. Nobody gets hurt. No damage. There's no damage, no causation, right? So you don't have a case, right? You generally don't have a case. Now, the government may come in and say, hey, Fran, you're mishandling handguns. We're going to suspend your license for a handgun. That's a different story. But in terms of liability, you're not going to have liability because you haven't fulfilled the four requirements, which is duty, breach, causation, and damages. Duty, breach, causation, and damages. All those things have to be shown. So they're outlined in the complaint. So you write up that complaint. You say, hey, the association had a duty to do certain things. The association's actions as described was a breach. I was damaged in the following way, and the association's actions or inactions are what caused my damage, right? So you allege those things. You just allege those things. In New Jersey, it's called notice pleading. So notwithstanding what some people think, you don't have to write a 400-page complaint that details everything that went on, right? So you don't have to say, and then I turned the wheel of the car slightly to the left, and then I turned the wheel of the car slightly to the right, and then they bumped into me, and then I got hurt, right? It's just they had a duty to drive their car safely. They didn't do that. They hurt me, and I got damaged, right? My leg was hurt, right? So notice pleading in New Jersey, and generally the pleadings in New Jersey will be freely allowed to be amended by the court so long as within reasonable time frames. So if you miss something in your pleadings, you can generally go back and add it. So it's notice pleading. And what about service? What about service? So service is something that we've talked about before. It's called due process, right? Which is basically notice and a right to be heard. A court will not generally grant judgment unless the plaintiff, the person who complains, the complainant, can show notice, proper notice on the person that is involved in the dispute. So in a formal litigation, you generally have service by acknowledgement. So, I know the attorney, for example, say I'm the association's attorney, and an attorney's going after the association on behalf of one of his clients or her clients. And that attorney calls me up and they say, hey, Fran, listen, I hate to say this, but we're going to sue you. Not me, but the association. And rather than sending the sheriff's officers out there to personally serve the board members and the management company and all that stuff, will you accept service? And then I'll reach out to the board and I'll say, hey, I heard from Mary Jones and she says she's going to serve us anyway. Can I just accept service on the association's behalf? Most associations will say, sure. Send the process server to Fran's office. We don't need the sheriff's officers showing up in our community and going to the house and knocking on the door of the board members and serving them with process, right? So service of process is important. You have to serve process properly. Otherwise, what happens if you don't serve process properly, the court will administratively dismiss the parties that you didn't serve properly, right? It's not like an actual hearing with a court order, although the court administratively enters an order. It's really a trigger that's in the computer system at the court level, where if proper service is not proven, the court will dismiss that party. And I'm involved in a case right now where that happened with respect to two parties. So that's service. Notify the carriers. I say this all the time, 1,000 times over and over again. If someone serves you with a complaint on behalf of the association, the board members, committee members, things like that, make sure you notify the carriers and demand defense and indemnification. Defense is they're going to pay your legal costs. Hey, carrier, we have insurance. We want you to hire a lawyer for us and pay the legal costs. That's number one. And number two, if God forbid we're found liable for something, we want you, the carrier, to pay the damages. We don't want you just to defend us. We also want you to pay for any damages that come about if the judge or the jury were to enter a verdict against us. So it's not only defend, but it's also liability demand. Usually, when you tell a carrier, they'll do a coverage determination letter or a reservation of rights letter, which will outline what they intend to cover, what they will not cover, and what rights they're reserving to object to your representation and liability coverage going forward. So notify the carrier. If you fail to notify the carrier on a timely basis of a claim, they can deny coverage based on failure to timely notify. So many associations say, Fran, we do not want to notify the carrier of this slip and fall where Bob fell down and broke his leg in front of the clubhouse. And he said, I'm going to sue you guys for it because Bob seems like a nice guy and he was just probably angry and he'll never sue us, right? Because when Bob files that complaint 1 year and 364 days later, the carrier is going to be like, wait a second, this happened 1 year and 364 days ago. Why didn't you tell us about it? We can't investigate it. We can't take pictures of the site. We lost evidence. We were prejudiced. We're not covering you. Now, it doesn't happen all the time, but it does happen. We were involved in a very large case, civil rights case, that the association was denied coverage because they failed to timely notify the carrier in a sexual preference discrimination case, right? So that was a major problem. I've spoken about that before. The association wound up having basically no nominal liability in terms of the claims itself, but they spent over 250 grand in attorney fees defending the case, right? Which is a major problem, right? That's a major problem. So that's the complaint. Then notify the carriers. What about the parties? So this I wanted to mention because a lot of people, both on the association side and the member side, if there's a dispute between the association and members, don't realize really what should properly go on. If someone wants to sue the association because there's a claim arising from the association's conduct or the board members' conduct in administering the association, who should they sue? They should sue the association, right? As Maddie, I think, just said, I think I read her lips. Nobody. They shouldn't sue anybody. They should resolve their differences amicably and go home and be nice to each other and enjoy your outdoor swimming pool and your indoor swimming pool, right? Look around you. It's a wonderful world, right? You don't need to fight all the time. But if you're going to sue an association, who do you sue? You sue the association. Well, I want to sue every board member and every committee member and every manager that ever worked there. And I want to sue the groundskeeper and the maintenance man and the lady who works the security shack. No, that is just madness, right? That's just madness. And what that does is that's like doubling the time you're shoveling money into the furnace. Because even though almost everyone knows that they have no claims against the individual parties, you still have to jump through all kinds of crazy hoops to get them out of the case, right? It's a real problem. And I see it all the time, right? So it's not an unusual problem, but it's a real problem. As I said, most courts will freely allow plaintiffs to amend their pleadings as part of the discovery process. If they later on find, oh my gosh, that property manager was doing something really bad and dirty, and I forgot to name her, and I didn't realize that she was involved in that. You go, hey, judge, I'm going to make a motion to amend my complaint to add a defendant. Most courts that I've dealt with would be like, really, why? Why do you want to do that? And the person says, well, judge, this is what I found. We found that she was putting money in her pocket. Okay, then. She did something wrong, right? But so generally the party should be the association, right? The entities rather than the individuals, right? So that's a major issue, and I run into it all the time. And the same thing happens with representing associations. So Fran, we want to sue because the landscaping is awful and all our lawns were brown last year. So Fran, we want to sue the workers who rutted up the dirt and causes the water to pond in there when they turn their lawnmowers around. And we want to sue the workers, and we want to sue the owner, that guy in the red pickup truck. If those that even speak English, we want to sue him too, because he should be speaking to us in English. God damn it, right? And that's not right, right? So no, we don't do that. Even though I hear those kinds of things all the time. No, we don't do that. Well, who do we sue? We sue the landscaping company. We sue the landscaping company. Now, again, if we find that the owner of the landscaping company or the guy in the red pickup truck who doesn't speak the language that we prefer, or the guy who is driving the zero-turn lawnmower has been stealing copper tubing out of our storage shed, that's a different thing, right? We add him in as an individual, and that's an individual claim against him. But if not, the association says, Fran, okay, we don't like the landscaping company. They did us dirty. Sue the landscaping company, not all their employees, not their owners, etc., not their shareholders if they're publicly owned entity. All right, so that's the parties. Motions to dismiss. What is a motion to dismiss? People hear this stuff all the time, and they think it's this big, sophisticated process, just like other things said in the law. I don't know the Latin for a motion to dismiss. I'm not big on Latin. I know some of you might be, though. I'll bet you Maddie knows Latin, but Greek at least. So on the Latin side of things, a motion to dismiss is basically like, listen, we understand what you're saying. We read your complaint. If we assume everything in your complaint is true, you still don't have a legal cause of action. So imagine somebody writes a complaint that says, somebody was running for an election, and Bob, the candidate, was standing in the audience, and he was saying his little speech, please vote for me. It's candidates night. And so one of the persons who asked a question of Bob says, Bob, I don't like you. I think your ideas are silly. I'm not going to vote for you. So why are you even here? And Bob says, defamation. Oh, you're nasty. I don't like you. Right. And Bob goes and files a complaint. On such and such, Maddie said, I don't like you. you're a nasty guy and I'm not voting for you. A motion to dismiss is this: judge, even assuming everything in his papers is true, he has no legally cognizable claim against Maddie. So we're not even debating the facts, whether or not she said nasty things, right? The things he said are not, she said are not cognizable, right? The case should go nowhere. There shouldn't be discovery. There shouldn't be depositions. For the purpose of this motion to dismiss, we are basically asserting that, for the purpose of argument, it's true. Still no claim. Make the case go away, Judge. So usually that's in a motion to dismiss. Motions to dismiss, there are different reasons for motions to dismiss. Sometimes courts have special powers, and people file in the wrong courts. So for example, you wouldn't want to file a business complaint in the family court. You wouldn't want to file a divorce action in the bankruptcy court. So in those types of cases, if they file in the wrong court, you can file a motion to dismiss and say, Judge, this is not about the complaint. This is just we're in the wrong court system. So let's get out of here, right? So that happens too. A motion to dismiss, if it's granted, kicks the case out without even going through the discovery process, because the court is saying either you don't belong here, go somewhere else, or your claims, even if we assume they're all true, don't warrant you getting any relief. So please just go home, right? So, and if a judge makes a ruling, a dismissal, oftentimes a dismissal is what's called with prejudice, right? If the judge makes the decision based on the law and the facts that have been asserted, it would be with prejudice, which means with prejudice is you cannot come back here with the same parties and claims and assert them again. It's with prejudice. It's over. I looked at everything. I'm the judge. It's over. You got no claim. That's with prejudice. People can consent to that and stipulate to dismissal with prejudice, which is fine. Dismissal by the court or by the parties without prejudice means the court will leave the case, leave that party open if the person comes back and attempts to rejoin them in a case. So the court is not closing the door permanently on those claims if it's dismissed without prejudice. Okay, so that's the difference there on dismissals. An answer is, right, you get served with a complaint. The complaint says you had a duty, you breached the duty, you had causation and you damaged them. The answer is just, no, I didn't have a duty. No, I didn't breach any duty that I might have had. I didn't cause any problem and there was no damage, right? So that's an answer. No, 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 right? Sometimes it's admitted, but other times it's most of the times, no, no, no. The answer is literally just like that. Each paragraph, they have paragraph 1 through whatever, you're answering each paragraph, right? Discrete paragraph. That's an answer. What's an affirmative defense? An affirmative defense is a claim by the defendant that asserts that they as something that they have to prove that would show that they're not liable in any case. So an affirmative defense might be immunity, for example. So someone says, I walked on the association, I came across the parking lot and there was ice, wasn't properly treated after a reasonable amount of time, slipped, fell, broke my hip. And the association says either no, or we don't know, we are without information to answer this. In their answer, but in their affirmative defense, they may say, Mrs. Jones is a unit owner. Bylaw section 5 has a provision that the association is insulated from tort immunity, right? Therefore, even if Mrs. Jones did walk across the ice and the association was negligent in the snow removal program, and she was injured, even acknowledging that she was injured, she can't recover from us because we have statutory tort immunity in our governing documents. So the association would actually have to prove a reason why it's not liable, right? That's why they call it affirmative. The defendant has to prove something. So you'd have to show that provision is in your governing documents, et cetera. What about a counterclaim? A counterclaim is somebody sues you and you go, well, I'm suing you. I got my claims against you too. So why don't you just pipe down, either settle this case or I'm going to go and jack you up. So that's a counterpunch. A counterclaim is a counter punch. Somebody sues you, you go after them. Counterclaim, third party complaint. Someone sues you and you say, first of all, I'm not liable, right? I'm not liable. You got nothing on me. But if I am in any way exposed to these claims, it's not just me. It's Mary Jones too. And you can actually bring third parties in to share the pain, right? If you think other people were involved in causing the injury, a third party complaint. You say, it wasn't me, it was somebody else, and I'm going to raise claims against that somebody else. What is discovery? Discovery is, at least in my experience, especially with larger cases, construction defect cases, transition from the developer and raising claims against the developer, is where the bulk of the money is spent, right? Because you're spending tens and sometimes hundreds of thousands of dollars, and believe it or not, sometimes millions of dollars, going through documents and records and emails, you name it, plans, deposing people from all walks of life that were involved in the community, um, and trying to find out what went wrong, and how it went wrong and how I can prove my case. So that's the discovery process. I call it the investigation to find facts that support your case and support your claims. That's discovery. Takes tremendous amount of time and a tremendous amount of money. So that's discovery. So if you can settle a case prior to discovery, it's a beautiful thing because it'll save you lots and lots of money. That's number one. The other thing is people forget this sometimes is associations, not as much, but especially with private entities, sometimes private entities settle cases just to avoid discovery because they don't want third parties poking around in their corporate books and records. You see what I'm saying? As a private entity, they just want to avoid having to open their kimono to people who are not part of the organization. And the discovery process generally allows for that. New Jersey has liberal discovery rules. So as long as it's relevant and reasonable, most courts in New Jersey will say you can go in there and look at it. Then after discovery ends, there's deadlines or case management orders set by the court. After it's all over, okay, everyone good? You got your discovery you wanted, you got your discovery you wanted. Okay, nice to see everyone. Now we're going to talk about motions again. And the motions that are, well, I guess most important are summary judgment motions, which are called dispositive motions. They're like a motion to dismiss, except that you've gone through discovery already. And in theory, everyone should be on the same page as far as undisputed facts. So once a judge has, say, 20 paragraphs of undisputed facts on each side, if the judge looks at that and goes, on these 20 issues, you seem to be in agreement, at least as to the facts. If I apply the law to those 20 facts, I'm going to make a decision on those 20 issues. On the remaining 5 issues that there are disagreements on the facts, those things would be held for trial, right? Because what trials are for is for a judge or a jury to make a determination of facts and apply the law to the facts as they are found, right? So judges play all different roles in the court system and the litigation system, but generally, if there's a jury trial, the judge is applying the law to what the jury is doing, and the jury actually makes a determination of the facts. So you hear this as a cliche in TV shows: reasonable man or reasonable woman or reasonable person. What would a reasonable person find in this case? Well, there is no such thing as a reasonable person, but for the purpose of litigation, it's the jury, right? The jury makes a determination and the jury makes a ruling, and guess what? You're bound with it, bound with that determination. And appellate courts, Supreme Courts, judges on motions for reconsideration or motions to set aside or vacate a judgment, are very, very, very loath to set aside a jury verdict. Juries are so respected in our judicial system that it's extraordinarily difficult to set aside a jury verdict, especially in the civil side. I'm not talking about criminal side on any of this, but especially on the civil side. But even in the criminal side, very hard to set aside a verdict. But there are many cases in association world where there are no juries, right? It's what you call a bench trial, where the judge is the fact finder. She says, hey, this is what I find. I find that Mary Jones seemed truthful and Bob seemed like not as truthful. So I'm going to find that what Bob's testimony was is the facts of this case. And now, as the same judge, I'm going to apply my understanding of the law to the facts I just found and give you the answer. So a bench trial, if you hear the words bench trial, or that's where the judge, she makes the determination or he makes the determination. And that's the trial. Trial is very involved, costs a lot of money in preparation. The preparation expense is far more than the time spent generally on the actual trial itself. So if you're going to spend time in a 2-day trial or a 3-day trial, you're going to spend a heck of a lot more time preparing for that trial and briefing things for the trial and briefing witnesses for the trial and reviewing deposition transcripts and reviewing boxes and boxes of documents or various online documents. You're going to spend a lot of money at the trial. And then everyone says, hey, well, we'll appeal. We'll appeal if we lose, whether it's a bench trial or a jury trial. Only a tiny, 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 tiny fraction of cases are successfully appealed. You know, the kind of misleading part about that is the cases that you hear about are the ones that are overturned, not the thousands and thousands and thousands of ones that are upheld, right? So the vast, I mean, overwhelming majority of trial court level decisions are upheld by the appellate division and upheld by the Supreme Court. So if you're consoling yourself saying, well, you know, the case didn't go in that well, but if it goes against me, I'm going to appeal it. Once you start thinking that way, you should think about settling your case right now, because it's a tiny fraction of cases that actually are winners on appeal. So that's it. Real quick, I blew through that fairly quickly, I guess. But yeah, so that's litigation. Seems so easy, right? I did that in 45 minutes. That's like the time that a CSI lasts, right? Fran, how come we can't do all our litigations that quickly? That's the problem, right? The real litigations cost tens of thousands of dollars. We have cases that are in the millions in terms of attorney fees and engineering costs when they're construction defect cases. So if you can settle the cases, settle them. If you can't, at least I would say pursue alternative dispute resolution. Jim goes on to say, our association started an affordable housing lawsuit against our own township and the affordable unit owners by necessity 2.5 years ago. It took 2 years till the trial took place. We are still waiting over 6 months for a decision from the court. We'll probably get appealed, and legal expenses are likely over 100K already. Lawsuits are not for the faint of hearted. You're right. However, this one will likely be a landmark case that will set a precedent that many of you that have development built after 2001 may rely on if you want to equalize maintenance fees. I'm going to go on. It's a good comment. Discovery is 100 times worse than a root canal. Thanks, Jim. I didn't describe it that way, but I totally get that. Oh my God, for the lawyers too, right? Discovery is 100 times worse than a root canal. 2 things to avoid that pain: make it a 30-minute exercise. Appropriate minutes from open meetings are important. Use an online system for all board communications, including minutes from all closed meetings. We've been doing this for the past 5 years, and our lawsuit Discovery was only sending our open meeting minutes and a log of all communication on this subject. That's great. Right. So Jim makes an excellent point. The cleaner your books and records are going in, the cheaper and quicker it will be dealing with. If you, anyone, we do have some CPAs who get on, right? There's a big difference between a CPA at tax time for the CPA who gets this nice indexed box of stuff, right? That's indexed and cross-referenced and all this other good stuff. Even better if it's an electronic format. And the person who walks in with 2 Tupperware boxes of garbage, right? So the 2 Tupperware boxes are going to cost the person a lot of more money than the person who has nice electronic records that can be downloaded. The other thing, Jim makes a good point. Arguing and fighting for precedent or principle is laudable. It is, but you're going to pay. You're going to pay. And it's a real challenging decision. I personally have filed lawsuits on the basis of principle and been successful in them. But it doesn't feel so great still after you spend tons and tons of money. It's kind of cold comfort to be like, yeah, that's nice, you won, but you're not getting attorney fees. And imagine what you could have done with that $100,000+, right? So there is a cost benefit thing. Things do get a little scary when people say things like, we want to punish the developer or we want to get that guy. Okay, those feelings, although they're valid often, need to be set aside because, again, that's the cash register ringing for the law firm. But Jim makes a good point that discovery is a hassle, but if you have your ducks in a row, it'll be much cheaper and much more expeditious. Are you expecting suits coming from the new reserve study law? That's Eric. Yeah, so I would say no question, Eric. No question. No brainer. The way this statute is written, even though it's well intended from a best practices standpoint, I think it's going to put a lot of associations and a lot of board members in the crosshairs, right? It's going to be interesting to see how carriers address these issues. And as Jim said, discovery becomes the root canal. And the first question that's going to come up in a deposition is going to be, who's your management company? My management company is ABC Management Company, Inc. Okay. In October of 2025, did they present you with a draft budget? Yes, they did. Okay, can I have a copy of it? Yes. Okay, is this the copy? Yes. Now, management told us earlier that they presented a draft budget to you for 2026, fully funding one of the reserve plans under the reserve study. Did you adopt that budget? Sir, let me ask you again. Did you adopt that budget? I'm going to ask you one more time. Right? Did you adopt the damn budget? And you know what the answer is. No. No, we did not adopt the budget. Right? So where that's going to get really hairy from a carrier standpoint is most governing documents and most insurance policies say that the association shall indemnify, defend, and hold harmless the board members if they are not guilty of gross negligence or purposeful misconduct. So that is terrifying for me, right? Because gross negligence is roughly defined. This is not a legal opinion, but gross negligence is roughly defined as you're aware of the risk, you're aware of the hazard, you ignore it, and you undertake the conduct anyway, right? So that is terrifying to me. Because does that mean that if someone sues the association and wins and names the individual board members because they say, the individual board members knew this, that, and the other thing, and they did whatever they wanted anyway because they didn't want to increase fees, are they personally liable? And is there any insurance coverage? That's terrifying. And I don't think, and I could be wrong, and I hope somebody can point to a section in the statute that says, this is only an administrative regulatory statute. It doesn't provide for a private right of action. But I haven't seen that language yet. And it scares me. It really does. So it's difficult. It's difficult to understand where that's going to go. But in the reserve funding world, that's why everyone celebrated when they passed the amendment for the 85%. That scares me too, the 85%, because it's cumbersome to undertake the process of sending out a notice required by the 85% provision and making sure everyone gets notice and making sure the seller actually gives it to the buyer and the buyer is aware and all those other fun things. And I think it's a real landmine, the 85% issue. So I gave you an example before. I don't know if you were on the call with me some months ago. I was at an open board meeting in Monmouth County, where we were in a synagogue, a packed synagogue, and the we did a presentation about, I think it was siding and roofing and decks, and it wound up that it was going to be a $14,000 per unit special assessment. And the meeting went well. We did the whole thing with the engineers and the specifications, and these are the colors and all that fun and games. And it was a very good presentation. And after the presentation, a young couple came up to me and said, Mr. McGovern, who can I sue? And I said, what are you talking about? Who can you sue? And they say, we just bought, this was last February, we just bought this unit in February. I said, okay, well, that's nice. Congratulations. And they said, well, we don't want to pay this $14,000. We understand there's a law that says the association is obligated to have an updated reserve study that is fully funded such that there's no need for a loan or special assessment when the time comes to maintain, repair, and replace the common elements. Who can we sue? And I said, that's not the question to ask me. You can go talk to your realtor, you can talk to your own attorney, talk to whoever you want. But there are the kind of questions that are going to be asked, right? The people who have purchased post adoption of this amendment, and I think it's going to cause some serious issues within the association world. It's going to cause a serious issue. Colleen says, when boards don't follow the law, is it better to just wait for election time and vote them out rather than filing suit? I think so, Colleen. So Colleen raised a good question. I'll say it again. When boards don't follow the law, is it better to just wait for election time and vote them out rather than filing suit? I think in general that's true. It really, I guess it depends on how serious the topic is. I have been unfortunately involved in the 30 years I've been doing this, 3 or 4 cases where people were really doing bad things and taking money, right? So you have reason to believe, a significant reason to believe, right, that someone's doing really bad things. You might have to act immediately. To begin with, in a situation like that, you got to involve counsel. But if it gets into things like, we see things all the time, I get these calls all the time. I got a letter from the DCA yesterday in one of my communities. Fran, the board signed the management proposal before the open meeting. Okay. And then at the open meeting, the board voted on the management agreement. And the statute says, and this is a condominium, the statute says on the Condominium Act that, and under PREDFA as well, that the binding votes must be taken at an open meeting. And somebody filed a complaint with the DCA that said the board president signed this proposal prior to the open meeting. And I wrote back to the DCA last night and I said, true, the board president did sign it, and that's probably not best practice. In the future, I'll tell them not to do that. But by virtue of law, that contract could not have been binding until it was voted on at the open meeting 2 or 3 days later, which is exactly what happened there. And so the contract became binding. So those types of things, and Colleen, you and I have dealt with lots of issues like that over the years. Those types of things, the notice should have been better. I'm concerned about, one ballot that was lost or things like that. Those things I think should be handled in-house. I think that's much better. Otherwise, again, not only are you setting tons of money on fire, your whole community turns into a war zone, right? It becomes really inhospitable in a lot of cases. But that's a good question, Colleen. Jim, we use Smartsheet as our online communication and document repository platform. It's relatively easy to learn and easy to use, as well as affordable. Beyond avoiding discovery, it's great for documenting and managing board projects if anyone is interested. So Jim is a representative of SmartStreet. He has a lot of stock in SmartStreet. I'm totally kidding, totally facetious, Jim. Jim has no stock in SmartStreet. He does not own SmartStreet, but he's just saying he has found it as a very useful tool for both day-to-day operation and also in the context of litigation. Yes, Colleen said when she was talking about the law, she meant PREDFA, which is, says their Planned Real Estate Full Disclosure Act, which generally used to just apply um, to certain things, but um, PREDFA really, with the later amendments in the past decade, um, is really an overarching umbrella, even though you still have the Cooperative Recording Act and the Condominium Act. PREDFA is an overarching statute that tries to encompass all real estate associations generally. And it doesn't cover necessarily all, but virtually all, right, for our purposes. Is there exposure with the reserve law's requirement to supply owners and buyers with the 20-point font notice with reserve is not fully funded? Yes, I mean, so Eric says that that's the 85% notice. I think there is because close your ears. A lot of people, and it's not through malice, just have a hard time getting administrative things right. They just have a hard time. Board members make mistakes, management companies make mistakes, managers make mistakes, and it provides, in my opinion, a huge opportunity for a gotcha. And I don't think anyone on this call could raise their hands and say that no, we have nobody in our community who's a gotcha person, right? There are gotcha people in every community, and which gotcha is not the worst thing in the world. If they're just saying, gotcha, 90 poo poo, I gotcha, you guys are all fools. But it is really hard when it rises to the level of lawsuits because it it costs so much money and creates so many problems. Um, can you speak to ADR? So Tyra, that's a good question. I'm going to do, since we're already at an hour, I'm going to do a separate session on ADR. I can do that next time. But alternative dispute resolution is awesome. I'm a mediator myself, as I said, um, and it's a great solution. Eric, continue with a follow-up. I'm wondering how the business judgment rule and fiduciary definition will work with the reserve laws as the laws are brand new. So what would a normal average person do with reserve law requirements? So unfortunately, right, a lawyer always has to say the same answer. You must follow them. You must follow them. So I get stupid calls all the time. I hate to say it that way. Fran, we're not going to do it. You cool with that? No, I'm not cool with that. No, I'm not cool with that. Right? Because I don't want to be the first person deposed. Right? So no lawyer on the planet's going to say, I'm cool with you breaking the law. Right? So the only way that I know of that associations can handle the reserve funding law at the moment is to comply, which can be really annoying. And in some communities, it's virtually impossible, unfortunately. So I have communities that say, Fran, you don't understand. If we implement the budget that management recommended to fully fund even the baseline finances, we are going to put half of our community members in collections with you, right? We're just going to take 100 people and make them delinquents because they can't pay it. And I don't have a good answer for that. But I also don't have a good answer for when boards say, can't we just not do it? I don't have an answer. I was on a call with a community from Atlantic County last month, and I felt really bad for them because they've been, we were just hired. They've been underfunded for a long, long time, and they're like, Fran, we just can't drop this bomb on these people. There's just no way. The whole place will be filing bankruptcy, and I don't have an answer. So that's the challenge. Excuse me, that's the challenge, Eric. It's really a struggle. It's a real struggle for all of us. And anyone who thinks they're alone in that boat, there are hundreds of associations, I'm sure, that are right there with you. And I don't know how it's going to come down. I think you're going to wind up with a lawsuit that goes to the appellate division, and you're going to wind up with opinions from insurance carriers regarding ability to cover that type of stuff. Because I don't know of any carrier who's going to be willing to cover short funded budgets. They're just not, right? We'd all be suing our carriers. Um, Eric says, forget collections. How will our buyers sell if our association property funds, but some other nearby association does not properly fund? So that's a really good point, Eric. What he's basically saying, and you correct me if I'm wrong, and this has always been the case, People just didn't know it. The law, not only does it require you to abide by the funding requirements, it also allows people visibility of the cost of ownership, right? So historically, even though association members were entitled to see the books and records of the association, including um, reserve funding reports and things like that, budget deficit reports, financial statements, um, they generally didn't ask, especially before they purchased. So literally, if you had the same housing product 1 mile from each other, townhome, people would drive up the street and say, one townhome has a $500 a month fee. It's the same townhome, essentially. The other one has a $250 a month of fee. I'm going to buy the one that's only $250 a month. Isn't that a win for me? That's awesome, right? And then I think what Eric's alluding to is that's actually madness, because the one that has the $500 a month fee maybe and virtually is in substantially better financial condition and probably substantially better physical condition than the place down the street that's been underfunding for 20 years. The thing you never want to hear, and some board members still beat their chest about this, we are so proud that we haven't increased fees in 15 years. My head explodes when I walk into a meeting and people say that, but it happens regularly, and it's a real problem. And then Eric goes on to say, which begs the questions, if assuming we properly fund, can we sue another association that does not properly fund or notify because it harms the owners? So the problem there, Eric, is I think it would be a problem of what's called standing. You may not have standing because I don't think, would be able to show harm. Somebody who was a purchaser there could show harm, direct harm. I'm not sure that you'd be able to find the causation piece in terms of that's a leap. There is some causation there because they say, hey, we had potential buyers that were misled to going to cheapo townhome association, and therefore you stole potential buyers from us. It's just a bit of a stretch, Eric, in terms of what's called standing, in terms of the causation piece. Somebody might take it on a flyer, right? I'm not sure, but I think long before that, we're going to see lots of lawsuits over new buyers who buy in, and then they're shocked by undisclosed true cost of ownership when the association has to special assess or secure a loan to make the repairs and replacements. But Eric's right; it harms the sellers. It for sure harms the sellers. So that's it. I'm out of breath. Oh my gosh, that was good. Good questions. That was good workout, everybody. It's great to see everybody. Lou says, is this new reserve study only in New Jersey? So the new reserve study law at least is in Florida, and there are different variations of this. It's state by state. Delaware has a similar law, and I believe it's spreading across the country. And you've heard me say this in the past. It's really taking a solution to the Champlain Towers disaster a bit too far. A lot of people would say that. So there's nobody going to argue that associations should be compelled to fully fund any structural members that would be a risk to life, health, safety, right? So that's the Champlain Towers case. But a lot of board members will come to me and they'll say, Fran, why do I have to fully fund for those fake plastic shutters that are on the front of the building? Who cares? If we don't want to replace the stupid fake plastic shutters in the front of the building at the end of their useful life, people will be able to look up there and be like, yeah, the place looks a little crappy, but I'm willing to deal with it rather than to pay 50 grand to replace the stupid plastic shutters, right? So it seems like in a perfect world, I'm a supporter in concept of the best practices embodied in the statute, but the impact on real people is very difficult at the moment. So I could see this statute being adjusted somewhat. I don't see that happening in the short term, though. So, but thanks, everyone. Have a great weekend. It's always wonderful to see everyone. I appreciate you attending, and please tell your friends. Thanks again. Have a great day. Bye-bye.